Education.
Section 183. General Assembly to provide for school system. The General Assembly shall, by appropriate legislation, provide for an efficient system of common schools throughout the state. There is very little in the published debates of the Constitutional Convention of 1890 to 1891 that directly sheds light on what the delegates specifically meant by the very simple and succinct language of Section 183, which was newly introduced to the current Constitution. Most of the discussion concerned an unsuccessful attempt to amend the section to provide for a compulsory system of public education. Supporters of the amendment argued that compulsory education was the wave of the future, while opponents contended that the proposal interfered with the rights of parents, and that farming, still the number one occupation in the Commonwealth, could be better taught on the farm than in the schoolhouse. In 1989, the Kentucky Supreme Court, in a landmark decision, held that Section 183 guaranteed the children of poorer school districts an adequate education similar to that provided in wealthier school districts, and that the public school system of Kentucky was therefore unconstitutional because it was inadequate, underfunded in most places, and lacking in uniformity. In Rose v. Council for Better Education Incorporated, the court ruled that the General Assembly had a duty to provide adequate funding for all school districts and to monitor the school districts to ensure that they were providing an adequate education. This case, initiated by a non-profit corporation consisting of 66 local school districts and a number of other local school districts and public school students, constitutes another example of the state Supreme Court finding a right in the state constitution not found by the U.S. Supreme Court in the federal constitution. See San Antonio Independent School District v. Rodriguez, 1973, and Cattermas v. Dickinson Public Schools, 1988. The court's decision led not only to more uniform funding of elementary and secondary public education in Kentucky, but to more uniform tax assessment and the enactment of the Kentucky Education Reform Act, KERA. KERA represented a revolutionary and controversial overhaul of the entire system of primary and secondary public education that substantially increased the power of the state government over public education and decreased the authority of the once all-powerful local school boards.
Section 184. Common School Fund. What constitutes, use, vote on tax for education other than in common schools? The bond of the Commonwealth issued in favor of the Board of Education for the sum of $1,327,000 shall constitute one bond of the Commonwealth in favor of the Board of Education, and this bond and the $73,500 of the stock in the Bank of Kentucky, held by the Board of Education, and its proceeds, shall be held inviolate for the purpose of sustaining the system of common schools. The interest and dividends of said fund, together with any sum which may be produced by taxation or otherwise for purposes of common school education, shall be appropriated to the common schools, and to no other purpose. No sum shall be raised or collected for education other than in common schools until the question of taxation is submitted to the legal voters, and the majority of the votes cast at said election shall be in favor of such taxation, provided the tax now imposed for educational purposes and for the endowment and maintenance of the Agricultural and Mechanical College shall remain until changed by law. The current Constitution incorporates much of the language of the previous Constitution about the Common School Fund, which had been established during the period of the Second Constitution, but raided by the General Assembly during an economic depression. To prevent future legislative raids, the drafters of the Third Constitution provided that the fund could only be used for the benefit of the common, or free public, schools. The requirement of an election to approve taxation for education other than in common schools represented an effort by Kentucky's private schools to undermine the funding for the state's only public institution of higher learning, the Agricultural and Mining College of Kentucky, which had been established in 1865 as a land-grant institution pursuant to the Morrill Act that gave substantial public acreage to state governments, which were to sell the land and use the proceeds to establish colleges. The Kentucky Court of Appeals had ruled in 1890 that the college was not a common school, in Higgins v. Prater, and therefore, had the original proviso stood unchanged, it would have required all public funding for the institution to be approved by the voters in special elections, a condition that would have seriously compromised the financial future of the school and allowed private colleges to dominate the higher education of the Commonwealth. However, supporters of the college, which eventually became the University of Kentucky, succeeded in adding language that seemed to exempt the institution from the voter approval requirement. In 1908, the Kentucky Court of Appeals ruled that not only did the language about A&M College permit legislative funding of that school without voter approval, it also allowed public funding of the normal schools, which eventually became regional universities, without a vote of the people, in James v. State University. The Kentucky judiciary has held that it is permissible under Section 184 for an urban county government to require a county school board to pay sewer user charges, in Fayette County Board of Education v. Lexington Fayette Urban County Government, 1985, and for a municipality to use school funds to employ a nurse teacher for the school system, in Board of Education of Bowling Green v. Simmons, 1932. But impermissible for a flood control district to assess a school board for a part of the cost of a flood wall, in Spencer County Board of Education v. Spencer County, 1950. The Special Commission on Constitutional Review of 1987 recommended repeal of Section 184.
Section 185. Interest on school fund investment. The General Assembly shall make provision, by law, for the payment of the interest of said school fund, and may provide for the sale of the stock in the Bank of Kentucky. And in case of a sale of all or any part of said stock, the proceeds of sale shall be invested by the sinking fund commissioners in other good interest-bearing stocks or bonds, which shall be subject to sale and reinvestment, from time to time, in like manner, and with the same restrictions, as provided with reference to the sale of the said stock in the Bank of Kentucky. This section, which requires the General Assembly to arrange for the payment of interest on the school fund, resembles a similar provision found in the preceding Constitution, but adds authority for the legislature to sell the fund's stock in the Bank of Kentucky and reinvest it. This section has been rarely litigated. The Kentucky Court of Appeals held that Section 185 did not prohibit the General Assembly from providing by statute for the use of escheat property in Louisville for the benefit of the public schools, in Commonwealth v. Thomases, 1910, but the section did not authorize the commissioners of the sinking fund to provide funds for the reconstruction of a building of the Industrial College for Colored People, in Rhodes v. Fields, 1927. The Special Commission on Constitutional Review of 1987 recommended the repeal of this section.
Section 186. Distribution and use of school fund. All funds accruing to the school fund shall be used for the maintenance of the public schools of the Commonwealth, and for no other purpose, and the General Assembly shall by general law prescribe the manner of the distribution of the public school fund among the school districts and its use for public school purposes. Originally, this section provided that the school fund would be distributed to each county on a pro rata basis according to the annual census of schoolchildren, that is, on a per capita basis. In 1941, voters approved an amendment to this section that reserved 10% of the school fund to be used in an equalization fund instead of being divided on a per capita basis. Another amendment, approved in 1949, set aside 25% for an equalization fund. In 1953, the current language was added by amendment that repealed the requirement that the fund be distributed on a per capita basis and left it up to the General Assembly to devise a formula for distribution of school funds to local school districts. Section 186 mandates that school fund distributions be used for the maintenance of public schools and pursuant to that requirement and similar language in Sections 171 and 184. The Kentucky Supreme Court has held unconstitutional a statute that authorized the state librarian to supply textbooks to private schools, in Fannin v. Williams, 1983. This case represents another Kentucky decision that differs significantly from a U.S. Supreme Court ruling. In Board of Education v. Allen, in 1968, the High Court ruled that an almost identical New York statute did not violate the federal Constitution. In the opinion of the Attorney General, a school board may expend school funds for a reward to apprehend vandals of school property, but it may not expend such funds to repair a street that is used by school buses to transport students to and from school.
Section 187. Race or color not to affect distribution of school fund. In distributing the school fund, no distinction shall be made on account of race or color. In 1996, voters approved an amendment to Section 187 that deleted language providing that separate schools for white and colored children shall be maintained. Following the Civil War and the end of slavery, Kentucky's African American residents demanded access to the public school system. In 1874, the General Assembly created a separate system for blacks, but it was seriously underfunded. In 1882, a federal court declared the funding mechanism unconstitutional, in Kentucky versus Ellis, prompting the General Assembly, with voter approval, to increase state funding for African American schools. Despite this increase, local school boards continued to maintain authority over expenditures for public education, often underfunding black schools. As a result, inadequate buildings, furnishings, and instructional materials, a shortened school year, and low quality of instruction too often characterized Kentucky's system of African American public schools. In 1904, the General Assembly enacted the notorious Day Law, which mandated racial segregation in private as well as public schools, and was upheld by the U.S. Supreme Court in Berea College v. Kentucky, 1908. In 1954, the U.S. Supreme Court held that statutorily mandated racial segregation in the public schools violated the 14th Amendment of the federal Constitution in Brown v. Board of Education. In the following year, in a federal court proceeding, parties seeking to delay the implementation of school desegregation in Kentucky conceded that the Brown decision invalidated the segregation language of Section 187 as well as the Day Law. In Willis v. Walker, 1955, supporters of the amendment to Section 187 argued that despite the invalidity of the segregation language, it should be deleted as an unwanted symbol of past constitutional racism.
Section 188. Refund of federal direct tax part of school fund, irredeemable bond. So much of any monies as may be received by the Commonwealth from the United States under the recent Act of Congress refunding the direct tax shall become a part of the school fund, and be held as provided in Section 184. But the General Assembly may authorize the use, by the Commonwealth, of monies so received or any part thereof, in which event a bond shall be executed to the Board of Education for the amount so used, which bond shall be held on the same terms and conditions, and subject to the provisions of Section 184, concerning the bond therein referred to. In February 1891, Congress enacted a statute that refunded to the states the unexpended portion of revenue collected from a direct tax passed during the Civil War. The framers of the current Constitution decided that the refund should be deposited in the school fund and that the legislature could use the money for other than school purposes if it replaced the funds so spent with a bond issued to the State Board of Education in the amount of the expenditure. In one of the rare rulings on Section 188, the Kentucky Court of Appeals declared in 1942 that pursuant to this section and Section 183, the common school fund of the Commonwealth was distinct from the funds of individual school districts, and that therefore the Commonwealth had erred when it asserted that the payment of fees under an allegedly illegal contract entered into by certain lawyers with certain school districts would operate to deplete the common school fund, in Commonwealth v. Reeves, 1941. The Special Commission on Constitutional Review of 1987 recommended that Section 188 be repealed.
Section 189. School money not to be used for church, sectarian, or denominational school. No portion of any fund or tax now existing, or that may hereafter be raised or levied for educational purposes, shall be appropriated to, or used by, or in aid of, any church, sectarian, or denominational school. There is no direct evidence in the debates of the Constitutional Convention on the motives of those who proposed this clear prohibition of the use of public school money for private religious school purposes, but the principal exponent of the measure expressed deep displeasure at the efforts of religious colleges, both in the legislature and the convention, to undermine public funding of the A&M College to become the University of Kentucky. He accused Kentucky's sectarian colleges of attempting to gain a monopoly over higher education in the Commonwealth, and not being able to tolerate competition that left religious training to the home and church. The Kentucky judiciary has used this section as one reason to invalidate a county fiscal court's award of most of its transportation subsidy to parochial schools in Fiscal Court of Jefferson County v. Brady, 1994, and, likewise, a contract between a county school board and a parochial school whereby the school paid the tuition for public school students to attend the parochial school in return for payment of part of the public school fund to the parochial school for the repair of buildings. In Williams v. Stanton Graded Common School District Board of Trustees, 1917. The courts have found no violation of Section 189 in a case where a public school board rented church property in which to conduct a public school. In Rawlings v. Butler, 1956, or where a church school paid the salaries of former church school teachers who began teaching in a public school, in McDonald v. Parker, 1908.
Thank you for viewing this history of the Kentucky Constitution. For more information, please see the following references. Citizen's Guide to the Kentucky Constitution by the Legislative Research Commission, available online. Or the book The Kentucky State Constitution by Robert M. Ireland, Oxford University Press.